Okay, well, it looks like I think we're starting now. And so we are live. Okay, just got the cue to go. Okay, so welcome. My name is Jack Fan. I'm an attorney based out of Dallas, but I also have offices in Austin and Houston. Today I'm going to talk about, well, I'm a lawyer, but I wish somebody had told me about some wills before I got started. So, okay, so let's see here. Okay, I'm going to cancel here. Okay, so anyways, just as a quick introduction, Texas legal intro. Let me just get the disclaimers out because, as lawyers, we have a lot of verbiage that we have to get out. Texas Legal is a statewide nonprofit legal benefit plan that was founded by the State Bar of Texas to better meet the legal needs of Texans. Texas Legal provides members access to over 400 network attorneys, and Texas Legal offers various insurance plan options. Contact information for the Texas Legal will be in the comments and description of this webinar. This is provided as not as legal advice specifically, but as a legal education today. Okay, so August is National Make-A-Will Month. Now, I didn't realize, again, that we had a National Make-A-Will Month, so we are doing a conversation today about wills and estate plan. So let's get started. What comes to mind when we really think about wills? Think about all the brochures, the photographs, heck, all the stock images. We're talking about pens and papers, gravels, elderly folks, dollar bills. And so you're inundated with this image that wills is about writing pieces of paper. And wills are really only for people who are old and maybe thinking about the beyond. But our conversation today is to talk about how wills are much more beyond that, because an estate plan is really about the plan, not about the pieces of paper itself. So what are some of the questions that often comes to mind that you should start thinking about before you even talk to an attorney? Well, first of all, does my will transfer my assets when I die? Again, most people think about wills and they think about pieces of paper that says last will and testament. Interestingly enough, we don't refer to last wills and testaments anymore. We just actually just call it a will. But the last will really just refers to not the last document, but rather the last executed document that you have. But even then, okay, does my will transfer my assets when I die? And the answer is resoundingly no. You see, the will by itself is really just a piece of paper. By itself, it doesn't do anything. For the will to have any effect, you would have to go to court to get a court to appoint someone as an executor, who then serves as the personal representative of the estate. At that point, the will may have some effect, but again, the will by itself isn't an automatic transfer. A lot of folks come to my office and they say, oh, well, my parents have passed away, my father passed away, so doesn't everything just automatically go to my mother, his wife, the surviving spouse? And the answer is not exactly. Because again, just because something is written on a will doesn't mean that things automatically transfer just by as a function of law. Someone, namely the executor, has to actually go through the process of creating deeds that transfers real estate, of collecting assets from one bank account and moving it into another account, maybe an estate account. And so the will by itself doesn't actually transfer anything. It's more akin to an IKEA set of instructions where, again, you get a document, you get a bunch of pieces of papers or tools, you have to start assembling everything together, and then at some point in time, you may have a bookcase. And so what should you do? Well, to the best of your ability, try to create an inventory. Write down a list of all of your assets, whether it's real estate, financial accounts, retirement accounts, personal items of sentimental value or economic value. But try to write down a list of everything that you have. And the reason why is that when you understand what you have, you can begin to start understanding how some of these assets begins, or what's required to transfer. Is someone's signature necessary to be able to transfer this asset? Typically, if you think of things with title, such as vehicles or real estate. But with bank accounts, is it necessary for someone to actually serve as the personal representative? Or could I just bring a death certificate into the bank or send it to a financial account by fax? And so when you start asking these questions, you have a better sense and a better understanding about how assets would actually transfer from one person to another. So again, does the will by itself actually transfer anything? No. It actually takes several steps in between, and it's understanding what steps are required. That's actually what is part of estate planning. So, the next question that I'm typically asked is, what exactly does an executor do? And most of the times when you think about an executor, you're thinking of someone, in a professional business suit, oftentimes with their hands crossed, looking very stern. Well, that's actually not necessarily what an executor needs to be. It doesn't need to be a professional. It doesn't need to be an accountant. It doesn't need to be a lawyer. Oftentimes, an executor is a family member. It's someone that you trust. And so, what exactly does an executor do? Well, pretty much everything that you can do. And so, while you're alive, who is the person that signs a deed when you purchase property? Well, that's you. And if you were to sell that same property, who would it be? Well, most likely it would be you as well, maybe your spouse or other owners of that real estate property. And so look into the mirror, whatever you can do, this other person can do as well. So for instance, if you were to go to a bank account, you were to ask for copies of your bank statements, well, your executor could do exactly the same thing as you as well. If you needed to negotiate debt, and one of the big questions is, what happens with all of my credit cards? What happens with all of those bank debts? Well, your executor would be able to negotiate, settle, and pay those debts potentially. And so the executor is someone who has that same ability unless you instruct otherwise. And we'll talk a little bit later about kind of the terms of the will. But the main thing to understand right now in terms of what the executor does is that it is someone who is responsible for collecting assets, someone who is authorized to conduct business on your behalf, and someone who is then also able to make gifts and distributions. So, what's our next step here? Well, really think about who a trusted individual may be. And so the executor actually ends up being the most important part about the will making process. And the reason why is that these executors, they're like referees. And so you want to find someone who is not only financially responsible, but also someone who has the emotional fortitude to really handle a lot of stress. And so oftentimes people ask me this question, well, I have an executor who doesn't live nearby. I mean, they're not in Texas. Is that okay? Well, in the age of online banking, remote hearings, it's actually not difficult for an executor not to actually physically be in Texas. They don't have to necessarily go to court because they may be able to appear by Zoom. And so the scope of who an executor could be is actually expanded lately because it's actually quite convenient to conduct court hearings or even online transactions. And so you may want to identify someone who is fiscally, not simply physically competent in terms of handling these business affairs. Oftentimes, people also ask the question of whether or not it's okay to nominate someone who might be out of the country. And again, for tax reporting requirements, it may require some additional steps, but it's not outside the realm of possibility. Because again, the purpose of who the executor is someone who is capable of making decisions. And so we go back to my very first question, which is, does the will transfer any of my assets upon death? And the will by itself doesn't. It's the executor who has the powers as the fiduciary to move assets between bank accounts or to sign pieces of paper. And so for this reason, the person that you choose ends up being the most important thing that you'll really need to think about. And beyond that, think about, what happens if this person is no longer available to serve, whether by death or disability, or it's just not their personal preference anymore. So oftentimes our wills includes languages to the effect that if my first name executor resigns, dies, or is otherwise incapacitated, then I name a successor executor to serve in his or her place. And so your action step is to think about these trusted individuals that you want to serve as a referee. Okay, what are some of the other questions? Well, a big question, and oddly, everyone always asks this: will the government get my money? The biggest concern most people actually have isn't who gets what. It ends up sometimes being, does the government get my money? I don't want to leave anything to the government. Again, I've paid all these taxes while I'm alive. The last thing I want is Uncle Sam to get more of my money. And so, does the government actually get your money? And the answer is a resounding no. And here's why. In Texas, we have an intestate succession regime or chart. And basically, what it says is if this person is not alive or to serve as this heir, then who is the next person in line? It is actually a very complicated process. And you look at it, you look at this molecular chemistry molecule, and the reason why is we actually go down to what's referred as morality. And what that basically says is if you're married, then the state of Texas has actually decided who gets what property, depending on whether or not you have children together. If you have children from outside the marriage, for instance, a prior marriage or just out of wedlock, for instance, then the property is split in a different way than if all of the children are actually from the same marriage. If you are married but you don't have children, then there's a formula for that. And it's then further bifurcated depending on whether or not it's separate property or community property. It's even then further decided whether it's real estate or whether it's personal property, such as cars and bank accounts. And again, if you're not married, then it goes to your parents. If you don't have parents who are then surviving, it goes to your siblings. If you don't have siblings as well, then it goes back to your grandparents on both sides of the family, on the maternal side as well as the paternal side. I probably go into a lot more detail than I really need to at this point. But what I'm really trying to say is the government is the very, 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 very last person to ever receive any money, because we have to go through your entire family tree before anything really ever escheats to the government. And even if it does escheat to the government, and I'll put this in quotation marks, all that means is it's actually just on hold in the government until your legal rightful heirs claim this property. Okay, so what do we need to think about? Well, what you want to think about is who are your intended beneficiaries. And so what I mean by that is that think about the individuals that you would like to actually receive something per your instructions. And this is particularly the case if you're trying to name charities or other individuals. And here's why. I've just gone through kind of a very long conversation about your family tree. What happens if you're married? What happens if you're married with children, without children? What happens if your parents aren't alive? What happens if they are? What happens if your siblings are alive? What happens if they're not? And so what you'll see is that by law, the beneficiaries tends to be your children. Sorry, actually, I'll start. Really your spouse, then your children, and then upwards and out. And so if you have a particular individual that you would like to have receive some sort of gift, we'll call them distributions, then you want to have them particularly identified, because otherwise they fall outside of the intestate succession chart or the intestate succession plan. And so oftentimes we'll meet with clients and say, well, my aunt passed away and I am her niece. I'm the person who took care of her. She wanted everything to go to me. And then I ask, well, did she write that in her will? Oh, well, she didn't have a will. Well, and then I say, well, but you have cousins, right? Your aunt had her own children. And the client would often say, yes, but they never took care of her. Well, then I said, well, unfortunately, because there's no will, everything goes to her children then. And if she had intended to leave you something, she really needed to have some sort of written instrument or some sort of written document that says that she wanted you in particular to receive her worldly possessions. And so I go back and really kind of, unfortunately, kind of harp and preach on this idea, because if your intended beneficiaries are not biologically related to you, then you really need to take extra steps to protect those rights. So a very common problem would be actually stepchildren. We have a lot of mixed family marriages these days. And a lot of times the parents who raise children together, they've always treated the children from a prior marriage, as the children of their own. And that's great. But the problem is if they've not done the next step, whether it's legal adoption or drafting a will, these stepchildren are not the legal heirs necessarily of the decedent. And so I say this because a lot of times we even face questions about adoptions by estoppel, which is another word for saying informal adoptions, which is very difficult to prove in court. And so if you wanted a gift to go to somebody else, whether it's a sibling, whether it's a charity, whether it's a niece or nephew or cousin, please make it very intentional, because it has to be included somewhere in a written document, namely a will. Okay, what should I include in my will? So that next question. We've gone in length and talks about a little bit about what the will is and what the purpose of the will. What do I really need to have in this will? And so here, let me just kind of give you the basics of what the will typically provides. Again, most attorneys, when we draft wills, it's going to be a relatively standard document for most people because it doesn't actually have or require a lot of flourishes. In fact, as I've said, and I'm going to say this many times today, the purpose of the will is not who gets what. It's really about who's in charge. So what exactly, whether it's an 8-page will, a 12-page will, 22-page will, or 50-page will, and I'll explain why I use those specific numbers in particular in a second. But whether those wills, no matter the length, it kind of boils down to these 4 specific concepts. And so let me explain the difference between the 8-page will, the 12-page will, the 22-page will, and the 50-page will. Well, it really just comes down to how much extra jargon or instructions we're including it. Basically, it's a difference between whether or not we need to do specific tax plans that are necessary to preserve some sort of tax benefit. And again, the longer the will, the more expensive your documents are likely to be. But as I said, even the 50-page will basically goes down to these 4 main concepts. So very first is about the identification of the family members. Are you married or not? Are there, is there any possibility of an informal marriage, for instance? Who are the children? Who are your adopted children potentially? So the main thing about the will, first and foremost, is to identify the family tree. Now, why is that important? Because without identifying the family tree, you have to go to court to do the long determination of heirship to determine the family tree. It's a very expensive process. Lawyers love it because it's very expensive. But you could do it by yourself. I've had a case before where it was one marriage, one child. There was no other marriages beyond my client and her husband. There were no other children, whether out of wedlock or predeceased, nothing. But in that particular case, we had to go through a determination of heirship, and the attorney who was verifying the unknown heirs charged a tremendous amount to verify those simple facts. And so I go back and I think about, well, if you just written it down and just said, I'm married and I only have one child, that could have saved your family a lot of money. So that's the first part of the will. The second part of the will is about the contingent distributions. Oftentimes for most of my clients, it's a very, very simple plan. We call them sweetheart wills. if I die, I want everything to go to my spouse. And if both of us dies, then we want everything divided to our children. That's 90% of all wills that we write. Now, things do vary a little bit if you have a mixed family situation, but for the most part, that's kind of what we want if we're married with children. Now, if we're a single individual, oftentimes we're thinking about other family members that we want everything to go to. And if it's not to them, oftentimes it's their children who would then receive those properties. And so your contingent distributions really is about this idea that, okay, if A happens, then what do I want? Sorry, if I want everything to go to A, and if A is no longer alive, then who would get that? Oh, well, then we'll say B. Okay, if B is not alive, then who would receive that property? Okay, then C. And so reasonably speaking, it doesn't need to go infinitum by any stretch. We often use the magic words and their errors in issue at the very end. So most of the wills that we have actually have a kind of a finite resolution. It usually just says heirs at law, which sometimes, for instance, as a good example, what it says is if I die, so if both me and my spouse, right? My spouse and I, sorry, grammar. My spouse and I both pass away, we want to go to our children. And if it doesn't go to our children, we want to go to their children, assuming that we have grandchildren at that time. And then if it's not to them, well, then half to husband's heirs and half to spouse's heirs. Because realistically speaking, that is such a far remote possibility that there's a catastrophic event that where everyone has died suddenly, that it probably wouldn't happen. And we would just simply default to Texas law. Now, beyond that, other contingent questions, right? Whether or not we want to make provisions that in the event of divorce, then would your spouse be treated as if that they predeceased you, effectively avoiding that particular gift? What if there's a family member who might rely on Medicaid? Do we need to contemplate special needs trusts for these individuals? What if I have a child that's a minor? And again, minor children under the age of 18 can't own any property. So you can't leave them anything either. Otherwise, they can't really touch the money until they're 18. So sometimes you want to think about these questions and incorporate those as part of your will, because you always want someone to be able to manage that money. In fact, most of my wills actually say that the child has to be 25 before that they're actually able to receive money. And the reason why is that we think that children at 25 magically become more capable of handling their finances. They should have finished college potentially by then, or at least they've worked for a few years so they have their own money instead. But I do have clients where our first question when I talk to them about adult children is, okay, imagine that both of you and your wife or you and your husband have both passed away now. Would your children be able to manage X amount of money immediately? And if they waver on the answer, even slightly, I'm going to say, well, let's think about this a little bit more, because I'm sensing that you're not ready to give them X amount of money, whether it's $500,000, whether it's $100,000, or whether it's $1 million. But that's kind of that question I always ask everyone is, if I gave your children this amount of money today, what would they do? Again, sometimes some parents and some of my clients are ready to say, yeah, I feel confident that they're able to manage that money. And I say, okay, done. We don't need a contingent trust. We don't need to have someone manage that money until a certain age. They're ready to go. So those are your contingent distributions questions. Now, your next question is, how are assets divided? I've already mentioned about the contingent distributions, meaning that do we need to hold on to that money for a little bit longer because we don't quite trust a certain individual to manage that money? In fact, just yesterday, I finished revising a client's estate planning documents, because when he had originally drafted all of his documents, his child was very young. Now his child has actually exceeded, he's now 25. And so the question is, okay, are they ready to manage that money? And my client said, yes. I trust him. He's quite competent, and he has a job. He's quite responsible. And so what happens with the contingent distribution provisions is that it actually just ends up not being applicable. You don't need to hand that money off to somebody else to manage. But beyond that, how are assets distributed? Well, first and foremost, would the executor be allowed to receive any compensation, for instance. And oftentimes this question is much more relevant when you have a non immediate family member serving as the executor. So for instance, parents with minor children may ask a sibling or a parent to take care of all of the finances while the children are still growing up. And in that case, does that family member need to be compensated, or could they just be reimbursed for time or fees advanced on behalf of their minor, children that they're taking care of? But oftentimes the executor ends up being a beneficiary. So again, for instance, most of my clients will name their spouse as the executor. If I, Jack Van, should pass away, then I want my spouse to be in charge of my estate. In that particular case, she's also the beneficiary. So does it really make sense for her to be compensated additionally with money that I give her that's also her money instead? And the answer is it probably just negates itself. So it's a relatively meaningless consideration. But if I'm asking my brother instead to manage my estate on behalf of my family, for my children, and also for my spouse, then maybe I want to give him that ability to receive reimbursements or to actually receive some compensation. Because serving as an executor is pretty much like a second job. It takes a lot of effort, particularly when you're dealing with beneficiaries that might be fighting. I went through a contested matter in which the question ends up turning on how much money do we sell the house for, and how much do we value the personal property that my father had, and who gets what. And that was a very long dispute that a third party executor was kind of in the middle of that sibling rivalry. Hours and hours. I stopped counting even my hours because it was just beyond what was within the budget of that family. So how are assets distributed ends up being kind of this very big question that you want to think about. Beyond that, of course, is questions about, well, is my executor allowed to pay debts and expenses? And oftentimes these are provisions that are built into the standard will. But there's actually one thing that's really interesting, which is known as the spendthrift provision. So a lot of people, when we talk about trusts, for instance, they all talk about creditor protection. And the idea that people don't understand is creditor protection, whether it's an estate or a trust, really comes down to one simple thing. It's the spendthrift provision that says whoever's in charge cannot pay the money of whoever owes that money of the beneficiary. So for instance, if I am the executor and the money is really for my children, and my children who are now adults have massive credit card debts, the credit card company can't come to me as the executor to say, hey, your children owe us money. You need to pay that money from the estate or the trust account to settle their debts. Because the spendthrift provision basically tells me, no, I can't give you this money because it's not mine to give yet. Once I give the money to my children who are the beneficiaries, then you can come after them for the money. But while I'm holding on to this fictional money and managing it on behalf of somebody else, I can't release that to you automatically until you go to court and get a court order and do a bunch of other things. And so that's actually kind of that creditor protection that most people are thinking about. And again, it's really just a stepping stone that says, I can't give you the money yet. You have to wait until I give it to whoever actually ends up owing you the money. So that goes down to our next point. What other provisions do we think about? Well, what rights do the beneficiaries have? Are they able to demand that money? So for instance, let's go back in that point number 2 about contingent distributions. If the children of, the minor children can't take money until they reach a certain age, whether it's 18 or 25, what rights do they have? Do they have rights to demand money? Or or is everything within the discretion of whoever the executor or whoever the trustee might be? Are they allowed to contest? Some wills will include a no contest provision that says, if you contest this will, then you take nothing. Well, okay, maybe that's the extent that we kind of want to have to avoid protests and wills contests. What about right to information? And that's a really big one. By law, executors don't have to provide information until 15 months after they receive letters testamentary. And so during this interim, do the beneficiaries of the estate have any rights to demand accounting or receive information? And so sometimes what you're really thinking about is, are these people potentially the same? Right? Again, most families, it's going to be the spouse who is the executor and the beneficiary or the distributee. And if that's the case, then does it really matter? And maybe it doesn't. But in other situations where the executor and the beneficiaries are different individuals, then to what extent are we protecting the rights of the beneficiaries to make demands? And so, what should you include in your will? Well, I think what you really want to think about is how complicated do you want to make everything? So, for instance, I go back and I talk about the difference between the 8-page will, the 12-page will, the 22-page will, the 50-page will. How much do you want to read? Because when I do the more complicated tax plans, I give them a book, and most people look at the book and ask, is there a summary? And it's like, yes, I do. Here's the 11-page summary. Because most people end up not wanting to read a set of instructions. So the more terms and conditions that you create, the longer you make your will, think about what effect it has on the person who's actually having to comply with the will, who's actually doing the work in the future. Because you can create a lot of restrictions. And I'll use one example. In one particular will that I helped a client draft, I said that his spouse could do anything with the assets. They could invest in real estate. They could borrow money. They can speculate if they want, because again, the money is the spouse. But if the executor and the trustee becomes somebody else, for instance, a corporate fiduciary like a bank or another family member, that he wanted to restrict the powers of the trustee such that the trustee can only invest in index-based mutual funds. So to basically be as conservative as possible. So we go from one end, which is my spouse can do anything with the money, to more conservative end, which is, well, they can only invest in certain types of investments that are conservative, right? Whether it's bonds, mutual funds that are index-based, but no crypto, for instance. So what should you include in your will? Well, really think about it. To what extent do you want to control from the beyond, from after death? Some family members want everything dictated. Some family members realize that it doesn't matter what I say. Let me just make it as easy as possible for my family. So, what is the action step here? Well, I would really strongly recommend that you prioritize your values. Think about what's most important for you. Think about what's most convenient or most valuable for your family. Because again, when we go back to that story about my clients who have specific set of instructions, well, I want X amount of money to go to my children when they turn 18, and then this amount of money when they turn 21, and then this amount of money if they marry this person of a particular ethnicity. It can get very complicated, but it's a question of if that's what's important for you to dictate how that money gets passed down, or to create what's known as incentives for your children. On the other hand, I want you to really also think about potential conflicts, because a lot of times our wills just say, I want everything to go to my children in equal shares. Well, what does equal shares actually mean? And that's really up to interpretation. For some family members, it's not that difficult because everyone is in agreement. We're going to just sell everything and divide the cash 50-50. But for other families, it could be more complicated because if the only asset is a house and one of the family members can't refinance to buy out the other siblings, then you might create a conflict between them because they don't know what to do with the house. Someone may value the house for sentimental reasons, but another family member may value the house for economic reasons. So when you think about these choices, what you're really trying to prioritize and think about and put in, in value of importance really is, what does your family care about? How do you want to be remembered? And do you need to take steps to avoid future conflicts between your children, or maybe your children and your spouse, or maybe your spouse and your parents? Think about that possibility, because everyone always walks in most of the time. Well, not everyone. Let's just say most of the time, people walk and say, oh, everything's going to be fine. Well, the problem is you'll never know because you're dead, unfortunately. And so as attorneys, we tend to be a little bit more conservative on this question and say, let's just think that this is going to be a conflict and let's anticipate what would happen then. Okay, so our next question, do I even need a will? And we've talked a little bit about the probate process. We've talked a little bit about trying to understand how assets transfer, whether it's real estate or financial accounts. And the answer actually is a little bit more convoluted. It's a maybe. Because nowadays, especially in Texas, so much of your assets can pass without actually needing a will. So let's think about real estate transactions. There are ways that you can draft deeds, whether it's with rights of survivorship or ladybird deeds or transfer and death deeds, that automatically trigger that if this person passes away, the current owner, then this property automatically goes to these individuals. Again, that's a document that you record and it creates an automatic transfer. Think about your bank accounts, your investment accounts, your retirement accounts. Most of them have a pay on death beneficiary. That's known as a POD. Most people, if you go open a bank account these days, then the bank account will probably have a form that says, if you pass, then would you want to name a primary beneficiary? Would you want to name a contingent beneficiary? And so what happens then is that if you passed away, your POD beneficiary would simply present a death certificate, probably fill out a W-9 form, and the bank would automatically cut them a check. You never have to go to court. And in fact, this is very important to understand. Your POD designation trumps the will. So your will, it doesn't even matter what you write in your will. If your will says, I want my Chase bank account to go to my daughter, but I want my Bank of America bank account to go to my son. But if your Bank of America bank account has a POD designation for your daughter, then it doesn't matter what your will says. The designation will trump and give everything to the daughter. And so, do I actually need a will becomes a little bit more complicated because of the fact that there are so many ways a proper plan can effectuate transfers of property without ever going through probate court. And so what is the action step here? It's really about having a plan. And so we go back kind of that very early question that talks about the will and understanding that the will by itself doesn't actually do anything. It simply designates an individual, whether it's the executor or it's called the administrator as well, to serve in some sort of capacity to follow a set of instructions. But beyond that, the will may provide guidance as to how certain assets are transferred. And so the will, again, is a game plan. It's a blueprint. But the blueprint is only useful so far as that someone knows what to do. And for you, as the person who is contemplating writing and preparing an estate plan, it's about understanding how all of your assets do transfers and what you want to do with them. So again, for instance, you talk about real estate. Some of my clients have one house. Well, have you talked to your children about whether or not they even want the house? I'll tell you that my parents have said, well, we want you, meaning me, to have the house when they pass. And I look at them as like, Mom, Dad, we don't want that house. It's old. It needs to be rehabbed. We're going to sell it. And so you may be surprised that your children don't even want the house. But what if you do have a child or a sibling or someone, a family member who's relying on that house? then again, that equation could be a little bit different because now you're trying to preserve a generational asset for somebody else. We talk about bank accounts. Stocks are very easy to liquidate, for instance. But when it comes to retirement accounts, it's a little bit different too, because those retirement accounts can't, most retirement accounts, whether it's a 401k or Roth IRA account, hasn't paid any taxes on it. So whoever receives that money, when they withdraw that money, would have to pay income tax. And so does it make sense to pass it on to the spouse? Does it make sense to skip ahead to maybe a minor child? All of these questions really turn on what you're trying to accomplish. Oh, sorry about that. Go back to presentation mode. Okay. So what are our goals, ultimately speaking? Our goal, did I lose? I apologize. Okay. Our goals today are to reduce your anxiety. It is to reduce conflicts, and it is to reduce future expenses. Because I find that the more that you understand about what is involved in this process, how the probate process works, what people can expect, then you reduce this fear and uncertainty because you're more familiar with this process. I think everybody wants a harmonious family. They don't want their children fighting over their assets when they're gone, because the last thing that you want to be remembered for is, oh, grandpa left us something, but we spent the next 5 years litigating. I'm an administrator. I'm still administrating in a state where the person died almost 10 years ago. And then we're still fighting over how the assets will ultimately be distributed between the family members. And it's been 4 years. I don't think the person who had originally passed away nearly a decade ago ever wanted their children to fight over these assets. Because now everyone just remembers, I'm just paying lawyers every day to argue. And now everyone has a bitter memory. And beyond that, again, let's reduce future expenses, because let's face it, probate is actually pretty expensive. Most people are like, oh, you need a will, you need a will. And a will is very important still. I'm not, please don't get me wrong about this. A will is vital because it serves as an insurance policy. It basically serves as an insurance in case something happens. Let's say you forget that you have this extra bank account that you didn't put a POD designation, or you didn't put into a trust, or you didn't make the proper plans for. Well, the will avoids a more complicated probate process that may cost thousands more dollars. But probating a will by itself may cost anywhere from $1,200 to $3,000 on average, depending on whether or not you're doing a munit, a title, or an administration. And again, that's having a will. So do you want to do your family members to do all the work for you in the future? Again, maybe that's your personality. Or do you want to make plans for them so that you reduce that complexity for them later on? Okay. So at this point, I'd like to welcome any questions that I have. I know I've gone through things relatively quickly for everyone. And I'm open to your questions at this time. Okay, so so people don't look at my cheat sheet of Canva, which is great. I love the visual effects that the software allows us to do. Okay, I'll move this down so I can see the camera. And if there are no questions in a second, then I'm happy to kind of discuss additional ideas and thinking points as well. Assuming I can find my original window. That seems to be a trick. Oh, there it is. Okay. Nope. Sorry. You're a very bad job. Okay, so let's talk about okay, so you know what? I see there's comment sections that I need to look at. That's what I'm missing. Okay. And I know Texas Legal did actually mention this in advance for me. So let's talk with Gloria. Okay. If you already listed a beneficiary in your 401k and an annuity, do you want to include it in your will? And I think there's two parts about understanding this question. The first part is actually understanding that the will is a public record. So, you know, the will can be looked at as kind of a public recognition of something. And what I mean by that is to say that sometimes you write things in your will because you want to memorialize uh, an idea, a statement, or something. So, for instance, if you have grandchildren, I typically don't write grandchildren into the will, but you may want to include grandchildren for sentimental reasons or just to recognize that they exist. You may want to exclude certain individuals. And again, you want to include that as part of your will. But the will is a public record. And so I tell a lot of my clients, do you really want everyone to know exactly what you own? Because I can search a will online for most of the larger counties and I can look at exactly what it says. And if you want to say, I have 3 houses, I have 5 bank accounts here, then again, by all means, have it listed as a matter of public record. Now, a lot of people do say the inventory, and at some point in time, you do have to provide the inventory of assets so that your creditors could access that. But again, that information isn't as readily available to the general public. There are certain steps that counties you have to take with certain counties to actually access that record. And so, do I want to include the beneficiary reference in my will? The answer is only if I want it to be a public record. Because for the most part, if your beneficiary ends up being the one and the same. So for instance, if I name my beneficiary to be my wife, I don't see the need to have individual assets listed to my wife. But if I intend for certain things to go to somebody else, then I probably want it to be a matter of public record to say, I want certain items to go to somebody else. I'll talk about the personal memoranda in a second, but specifically about the 401k, specifically about the annuity and other life insurance policies. Typically, if I have someone already designated by contract, then I'm not going to include that as a reference point on the will, particularly because of future changes. Let's say that if you named your children as the recipients of your annuity, and you have a falling out with your children, with one of the children instead. Well, if I named it as part of the will, I have to go through the entire estate planning process of either drafting a new codicil or a brand new will. And that all requires, additional witnesses. It requires notary stamps. It requires hiring an attorney. So it's a complicated process, and pony and dog show to rewrite that will. But if you just change the annuity, say like, I really don't like my son anymore, I'm taking him out of this beneficiary designation, I don't have to do anything else other than change the beneficiary designation. So in a shorter answer, I think the answer really comes down to is it's a matter of convenience. And if you don't want the hassles of redoing everything or making everything a public knowledge, then maybe let's not include it in the will. But if I do need to make it known because people are going to contest it, then I will include it in the will. So this brings up the next question, which I mentioned briefly, which is the question about memorandums. Because most of the times my wills will include a provision that says, from time to time, I may leave a personal memorandum that I direct my executor to follow. And I use this example because I go back to that. You don't want to always change your will. I've had clients that says to me, well, Mr. Fan, I just bought a new car. Do I need a new will? It's like, no, because you're giving everything to your spouse. Oh, Mr. Fan, I just sold the car. Do I need to change the will again? It's like, no. You don't have the car, so everything goes to your spouse, and because the car no longer exists, then it's really cash and it all goes to your spouse. And so changing a will could be expensive, right? It's also unnecessary if the plan is still the same. So this memorandum, and I've told people, look, from time to time, my keys are going to go over to my daughter. And then I'm going to have this mouse go over to my son. And then at some point in time, if I decide to say, you know what, this mouse really should go to my son instead, and my keys, not the card, just the keys by itself will go to my daughter instead. If I want to switch them out, I can just change the personal memorandum, which is a set of instructions to my executor, and that's perfectly fine because I've already chosen someone who I trust to be able to handle all of these affairs. And so the personal memorandum ends up being a very convenient way to designate items that are maybe personally significant, but of very little economic value that doesn't necessarily require an attorney. So, Nancy, sorry, there's some additional questions. Okay, so there's another question. If I create a will in Texas, but eventually move to another state, will I need a new will in that state? And the answer is not really. So we have a thing, a constitutional principle called comity, which says if a will that's validly executed in a different state will be recognized in anywhere else in the United States. But here's why you might. I remember going to court once, and it wasn't me. It was the attorney before me. And the attorney brought in all the witnesses. They were before the judge, and they were about to say, Your Honor, we have an Indiana will here. We're ready to probate. My witnesses are here to testify. And the judge looks at the attorney and says, how do I know that this will was validly executed in Indiana? Send me a brief. Bring me bring me a written memorandum that explains that this will complies with Indiana law. And the attorney looks around and looks at the witness, his client's like, oh crap, we have to come back. And so the answer is if the will is created, in Texas and you move elsewhere, is it still a valid will? The answer is yes. But is it easy to probate a Texas will somewhere else? The answer is I don't know, because I don't know what state you're going to be in. I don't know what judge is going to make certain requests. And so the will can stay the same, but the estate plan may change because of the fact that, again, if you're purchasing real estate or you have differences with regards to who gets what, maybe that plan needs to change. And so I'll briefly add on this point. When do I need to start thinking about changing wills? And I typically say 3 reasons. Reason number 1, there's a change in the family, marriage, divorce, additional children. Number 2, there is a change in assets. So for instance, you may suddenly win the mega millions and get $1 billion, for instance. Okay, well, there's suddenly now a very different set of circumstances where my original plan, which is a catch-all plan, may no longer be appropriate. Number 3, a change in laws. So for instance, between 2017 and 2026, we have an insane exemption amount for for estate taxes. It's currently for this year, it's $12,060,000. But again, if you wrote your will back in 2000, 17 years prior, the exemption amount was $1 million, where everyone had a very different estate plan. And so a change in laws, whether for tax reasons, for another reason, really will change things where you may want to reconsider. Okay, so we have another question. Would setting up a life insurance policy with grandchildren as beneficiaries be a good way to leave them money? I'm going to say no, with kind of a very shocked no, but with a caveat. It depends on how old the children are, the grandchildren specifically. And here's why. Most people will designate their children as a beneficiary for life insurance policies and other accounts. But if that life insurance policy is naming a beneficiary that's under the age of 18, they can't touch the money until they're 18. Otherwise, someone has to go to court to be named as a guardian of the estate to be able to collect that money and manage that money and then be bonded for that money, which is to get insurance that they're not going to waste the money away. There are so many strings attached to that. And so the question is, does naming a grandchild as the beneficiary of a life insurance policy make sense? Not outright. This is where we'll start talking about whether it's contingent trusts within the will or just a trust by itself. And for people who are on the Texas legal plan, a trust is typically included as part of your benefits. And so do look at your policy amount, because it is better to leave money with additional sets of instructions, typically inside a trust, that says, I want somebody else to be able to receive the money without court supervision, to manage that money on behalf of minor children or grandchildren, and then to distribute it once they become a certain age. And so my answer is, it depends on how old the grandchildren are, because that really changes things. So there's another question is, if I make a second will, what happens to the first will? Is it automatically canceled? And the answer is no. Here's why. A second, and this has existed before. This is why will contest exists. If you have two wills and the second will doesn't cancel the first will, then both wills are valid wills. And so if your second will says, I want the house to go to my father, and the first will says, I want everything to go to my mother, then the contest exists as to what the heck does both wills mean together. By default, every will I includes in the very first preamble. It's the last line of the preamble. It says, I expressly revoke all prior wills and all prior codicils. So it cancels out the prior will as a matter of written instructions. But if you don't have that included, then both wills exist at the same time. And then people will have a fun time trying to interpret. I'll use this one example because this is why I love form wills. Somebody came in to my office and they had a dispute with family members, and they presented a will that was clearly done by rocket lawyer and DIY. I love it because it was very expensive for them to figure out and probate everything. What happened was, in one section of the will, it said, I expressly disinherit my wife. And then later on, it says, I give everything to my wife. And so we looked at this as well. Clearly, there's a conflict in language. What do you even mean? So even within the same will, they had problems telling what they wanted to do. And so all this is to say is, lawyers love poorly drafted documents from time to time, because that's how they make money in probate. A properly drafted will doesn't avoid probate necessarily, but it minimizes that possibility of a conflict in the future. But more important than the will is the plan itself, because I keep telling clients, my job isn't the pieces of papers that I draft for you. My job as the attorney is to help you understand how everything actually moves, how assets actually transfers, and to walk you through the step. Because if I've done a very good job as an estate planning attorney, you'll never go through probate. Your family can avoid all of the headaches and hassles. And so I'll conclude on this note that I share all the time, because it's a very valuable lesson in terms of understanding how things can be very complicated and very expensive. I had a client who had an out-of-state will. When he moved to Texas, he forgot to include the house in the will, but he did everything else correctly. And so within a month, within 30 days, we transferred all of his assets to the beneficiaries that he named for his life insurance policies, for his retirement accounts, for everything on his bank accounts. That was done within a month. Why a month? Because that's how long it takes to typically get a death certificate. And I'll get to the question for about the MERP in a second. And so the house took a year to go through probate because there was a contest between the spouse and a child from a prior marriage. It took 1 year to move the house, but it took 30 days to move all of the other money. Why is that? Well, that was just poor planning on that part. Okay, so I do have another question. Would MERP trump a will? And the answer is they're actually two very different things. So MERP is the Medicaid Estate Recovery Program. That does not trump a will, because the will is simply designating to the court who you want to be named as an executor. What MERP does instead is that if you probate a will and you create a probate action, then if the person who had passed away had received Medicaid benefits while they were alive, then the state of Texas has the ability to place a Medicaid lien against that property. It's a class 4 creditor, basically. And so if you probate a will, you end up subjecting the estate to Medicaid recovery. But here's a trick. If you don't probate a will, then, or you don't probate an estate, then Medicaid never attaches. And so it's that analogy, if a tree falls in the forest and no one's around to hear it, does it still make a sound? If you have an estate that doesn't have a probate and there's a Medicaid lien that can't be attached to a probated estate, then can the state of Texas recover something? And the answer is no. Until the state legislature realizes this loophole and does something else differently, there is a very valuable reason why you want to avoid probate, because you avoid Medicaid recovery. So with that being said, I do appreciate everyone who has attended this program. I hope that you've learned a little bit more about what you want to think about before you first speak with an attorney. There's a lot of questions I know that you have, and there are a lot of great attorneys who are available for consultation through your Texas legal plan. And also take advantage, because I think, again, most people have free consultations. Most people also have the ability to speak with a lawyer and have all of these documents prepared with a lawyer through your legal plan. It's an amazing service. And I'll answer one final question, because I love answering questions too. Why would a MERP exist? Okay, so again, why would Medicaid estate recovery exist? And the answer is, if an individual received Medicaid benefits because they were eligible for skilled nursing facility care, then the Texas Health and Human Services probably wants that money back. So basically, if the state of Texas paid for your nursing home, they want an opportunity to get that money back from your estate. So with that being said, I do thank everyone so much. I thank Texas Legal for the opportunity to share. And again, August is National Make a Will Month, so please consider making a will or talking to an attorney about drafting a will. Thank you so much.